Swayam Prabha. Digital India. Educated India.
Hello friends, I welcome you all viewers and the aspirants of legal education to the third session on the course Law relating to women and children. In this third session of the course, I will discuss on the topic protection of women under Indian Penal Code, that is now the Bharatiya Nyaya Sanhita 2023. Crimes against women and girls is a serious disrespect to the human rights. The instances of violation of women's human rights and by doing violence against them poses the greatest challenge in achieving the great constitutional objective of gender equality. Various forms of violence and crimes against young school going girls and women leave profound and extensive impacts on their lives, stifling their potential to grow, lead, prosper and thrive. Presently, we witness the violence and the increasing crimes against women in some or the other manner, which shows the ferocity and wastefulness of the atrocities committed against women in recent years. The worldwide campaign for the obliteration of violence against women is evidence to this fact. The changes in the living standards, lifestyle, imbalance in the economic growth, changes in the social philosophy and insufficient concern for the moral values contribute to a toxic outlook towards women, due to which there is multiplication in crimes against women. Such incidents are a matter of serious concern and some structural mechanism to address these issues is absolutely necessary, so that the women of India could live with respect, honor, dignity, liberty and peace in an atmosphere free from atrocities, denigration and heinous crimes. In India, since the Vedic time, the law has always been accorded special protection to women because of the reasons like their physical structure, social status, their ignorance towards legal rights and duties, for being mostly illiterate and their economic independence on men, etc. In India, legal system from very ancient time, the special provisions have been provided for the protection of women and for maintaining their dignity. Accordingly, the Indian Penal Code also provided some special provisions to protect the women from violence, exploitation and indignity of their person. Though the Indian Penal Code generally does not make any distinction on the basis of sex, but keeping in mind the social conditions and social norms prevailing in the country, the IPC has provided special provisions to give the protection to women who are the victim of various offences relating to their sex. These special provisions deal with the special offences relating to women who face varied problems in their public life because of their womanhood and social status. Now, see that what are these provisions which are included in Indian Penal Code to treat especially the women or to deal with the offences against the women especially. The provisions of IPC, now this Indian Penal Code has been amended, the new criminal law has been introduced by the Indian legislature by making the amendments in all the fields of criminal law, and IPC is substituted by Bharatiya Nyaya Sanhita 2023. Because this Bharatiya Nyaya Sanhita is still not practically enforceable and we are not very well known about the name of this new law, and therefore, I included the old provisions of IPC and how these old provisions which were found in IPC are renumbered in the new act in Bharatiya Nyaya Sanhita. I have arranged these new provisions also within the discussion. See the first provision which was included in IPC to deal the offence against offences against the women, that was the offence of dowry death. The offence of dowry death was included in the IPC in section 304B. This 304B, this provision is now numbered as section 79 Bharatiya Nyaya Sanhita. The same provision we will find now in Bharatiya Nyaya Sanhita. See old section 304B dowry death, which is substituted by section 79 of Bharatiya Nyaya Sanhita. Clause 1, where the death of a woman is caused by any wounds or bodily injury or occurs otherwise than under normal circumstances within 7 years of her marriage, and it is shown that soon before her death she was subjected to cruelty or harassment by her husband or any relative of her husband for or in connection with any demand for dowry, such death shall be called dowry death, and such husband or relative shall be deemed to have caused dowry death. The offence of dowry death has been defined by section 304 clause 1. Very expensive definition of dowry death has been given, wherein there are some elements like if the death of woman is caused within the 7 years of marriage, and number 2, if just before the death she was subjected to cruelty by her husband or any relative of her husband, or there was any demand of dowry death or this cruelty was connected with the demand of dowry by her husband or by any relative of her husband, then in such circumstances that death shall be considered to be dowry death. Some other elements are also included, that if this death is caused due to any wounds on the body of the woman or otherwise also, but if any such connection is found that the death was caused because of the cruelty in connection with the demand of dowry were by the husband or her relatives, then such a death of a woman shall be considered to be dowry death. See the punishment. Whoever commits dowry death shall be punished with imprisonment for a term which shall not be less than 7 years, but which may extend to imprisonment for life. So, minimum punishment has been prescribed as 7 years, and this 7 years punishment can be extended to the life imprisonment. Section 304B was added in Indian Penal Code by way of Criminal Law Amendment 1986. Then the next offence which was included in IPC was section 354. Now this section 354, the offence which was included in section 354 of IPC, now it is section 73 Bharatiya Nyaya Sanhita 2023. Assault or criminal force to woman with intent to outrage her modesty. Whoever assaults or uses criminal force to any woman intending to outrage or knowing it to be likely that he will thereby outrage her modesty shall be punished with imprisonment of either description for a term which shall not be less than 1 year, but which may extend to 5 years and shall also be liable to fine. From the range of the punishment is from 1 year to the 5 years. Then section 354A, now it is substituted by section 74 Bharatiya Nyaya Sanhita. Sexual harassment and punishment for sexual harassment. Sexual harassment has been very general crime or offence against the women. Subsection 1 says that a man committing any of the following acts: physical contact and advances involving unwelcome and explicit sexual overtures, or a demand or request for sexual favors, showing pornography against the will of a woman, making sexually colored remark, shall be guilty of the offence of sexual harassment. So, all these actions on the part of a man shall be considered to be the offence of sexual harassment. If a man acts in such a way, he makes any physical contact, any advances involving unwelcome and explicit sexual overtures, if there is any demand or request for sexual favors by a man, if a man shows pornography against the will of the woman, or if a man makes any sexually colored remarks, then such an act on the part of man would be considered to be the sexual harassment of that woman. And see the punishment. Any man who commits the offence specified in clause 1 or clause 2 or clause 3 of subsection 1. Clause 1, clause 2 and clause 3, see again clause 1. Any man makes physical contact and advances involving unwelcome and explicit sexual overtures, if a man demands or requests for sexual favors, if he shows pornography against the will of a woman, then he shall be punished with rigorous imprisonment for a term which may extend to 3 years, or with fine, or with both. The maximum punishment, maximum imprisonment of 3 years is provided. But if a person acts in a way which is provided under clause 4, see clause 4, if he makes sexually colored remarks, then he shall be punished with imprisonment of either description for a term which may extend to 1 year, or with fine, or with both. So, for any acts provided under 1, clause 1, 2 and 3, maximum punishment is 3 years and fine, or both. And for the act done which is provided under clause 4, then if the sexually colored remarks are made, then the punishment is maximum of 1 year, or fine, or both. See section 354B. Now, it is substituted by section 75 Bharatiya Nyaya Sanhita 2023. Assault or use of criminal force to women with intent to disrobe. Any man who assaults or uses criminal force to any woman or abets such act with the intention of disrobing or compelling her to be naked shall be punished with imprisonment of either description for a term which shall not be less than 3 years, but which may extend to 7 years and shall also be liable to fine. Minimum punishment is 3 years for using any criminal force or for assaulting a woman with the intent to disrobe. The minimum punishment is 3 years and the maximum punishment is 7 years plus fine. So, from 3 to 7 years imprisonment plus fine, this is the punishment provided by 354B for the offence of assaulting or using criminal force with the intent to disrobe a woman. Section 354C of IPC, now it is substituted by 76, section 76 of Bharatiya Nyaya Samhita. This is voyeurism. Any man who watches or captures the image of a woman engaging in a private act in circumstances where she would usually have the expectation of not being observed either by the perpetrator or by any other person, at the behest of the perpetrator, or disseminates such image, shall be punished on first conviction with imprisonment of either description for a term which shall not be less than 1 year, but which may extend to 3 years. This is for the first time, and shall also be liable to fine and be punished on a second or subsequent conviction with imprisonment of either description for a term which shall not be less than 3 years, but which may extend to 7 years and shall also be fined. Then section 354D, which relates to stalking, section 354D of IPC, which is now substituted by section 77 Bharatiya Nyaya Samhita 2023. Any man who follows a woman and contacts or attempts to contact with women to foster personal interaction repeatedly despite a clear indication of disinterest by such woman, or monitors the use by women of the internet, email or any other form of electronic communication, commits the offence of stalking, provided that such conduct shall not amount to stalking if the man who pursued it proves that it was pursued for purpose of preventing or detecting crime, and the man accused for stalking had been entrusted with the responsibility of prevention and detention of crime by the state. If it was pursued under any law or to comply with any condition or requirement imposed by any person under any law, or in the particular circumstances such conduct was reasonable and justified. So, 3 exceptions are given, so that the misuse of this provision of IPC and Bharatiya Nyaya Samhita cannot be made. Otherwise, the stalking is offence, but if it is, if that shall not be amount to be the stalking, if it is done with the range of these 3 actions on the part of the man. Subsection 2 provides for the punishment for the offence of stalking. Whoever commits the offence of stalking shall be punished on first conviction with imprisonment of either description for a term which may extend to 3 years and shall also be liable to fine and be punished on a second or subsequent conviction with the imprisonment of either description for a term which may extend to 5 years and shall also be fined. On the first conviction, the maximum punishment is 3 years, and for the second conviction it is 5 years and also the fine. Then see section 366 of IPC, which is now substituted by section 85 of Bharatiya Nyaya Samhita 2023. Kidnapping, offence of kidnapping, abduction or inducing woman to compel her marriage. If any woman is compelled or any woman is induced to compel her to be compelled for marriage, if she is, if there is any kidnapping of the woman, if there is any abduction of the woman, then whoever kidnaps or abducts any woman with intent that she may be compelled or knowing it to be likely that she will be compelled to marry any person against her will. This is very important provision included in IPC and now which has also been included by Bharatiya Nyaya Sanhita. Because in the country like India we see that mostly often the women are compelled to marry a person even by family members. There is always the compulsion to the girls and women to marry a person, and if a woman is kidnapped, if she is abducted or she is compelled to marry for the purpose or the kidnapping or the abduction is made to induce her to compel her marriage with a person against her will, then or in order that she may be forced or seduced to illicit intercourse, or knowingly it to be likely that she will be forced or seduced to illicit intercourse, shall be punished with imprisonment of either description for a term which may extend to 10 years and shall also be liable to fine. And whoever by means of criminal intimidation as defined in this code or of abuse of authority or any other method of compulsion induces any woman to go from any place with intent that she may be or knowing that it is likely that she will be forced or seduced to illicit intercourse with another person shall also be punishable as aforesaid. See that the punishment which is prescribed in the provision is, this is for a term which may extend to 10 years and shall also be liable to fine. So, maximum 10 years imprisonment and plus fine, this is the punishment for the offence committed under section 366 of IPC. Now, it is section 85 of Bharatiya Nyaya Sanhita. See the scope of this provision, that if any person kidnaps, abducts or induces a woman to compel her marriage with a person against her will, number 1. If she is kidnapped, she is abducted, she is induced to have the illicit intercourse with any person, then the punishment is maximum imprisonment of 10 years plus fine. Section 66A, procuration of minor girl. Now, it is substituted by section 94 of Bharatiya Nyaya Sanhita 2023. Whoever by any means whatsoever induces any minor. Now, this minor word is substituted by child below the age of 18 years. The term girl is now substituted by the term child under the present section 94 of Bharatiya Nyaya Sanhita. So, the minor is clearly mentioned, any child below the age of 18 years, and girl is substituted by the child. It means that both the girls and boys, they are included within the meaning of the section. Child under the age of 18 years to go from any place or to do any act with intent that such girl, now child, may be or knowing that it is likely that she, now child, will be forced or seduced to illicit intercourse with another person shall be punishable with imprisonment which may extend to 10 years and shall also be liable to fine. Kidnapping, abduction to induce any woman and the procuration of any child below 18 years for the purpose to compel him or her for illicit intercourse. Now, it is punishable for the term of 10 years imprisonment and the fine. Now, see section 366B, importation of a girl from foreign country. This section 366B, now it does not seem to be existent in new Bharatiya Nyaya Sanhita, because it seems that the legislature considered the earlier any sale or any purchase of any child from foreign country, which is now introduced in the new act or new code, that is Bharatiya Nyaya Sanhita, is the substitute to this provision. So, in the present Bharatiya Nyaya Sanhita it is not present. See section 372, selling minor for purposes of prostitution, etc. Now, this 372 of IPC is substituted by section 96 of Bharatiya Nyaya Sanhita, and according to section 96 of Bharatiya Nyaya Sanhita, whoever sells, lets to hire or otherwise disposes of any person. Now, this person is substituted by child, birth child under the age of 18 years, with intent that such person shall at any age be employed or used for the purpose of prostitution or illicit intercourse with any person, or for any unlawful and immoral purpose, or knowing it to be likely that such person, now child, will at any age be employed or used for any such purpose, shall be punished with imprisonment of either description for a term which may extend to 10 years and shall also be liable to fine. See section 373, buying minor for purposes of prostitution, etc. Now, it is substituted by section 97 of Bharatiya Nyaya Sanhita 2023. Whoever buys, hires or otherwise obtains possession of any person, now child, under the age of 18 years, with intent that such person, now child, shall at any age be employed or used for the purpose of prostitution or illicit intercourse with any person, or for any unlawful and immoral purpose, or knowing it to be likely that such person, now child, will at any age be employed or used for any such purpose, shall be punished with imprisonment of either description for a term which may extend to 10 years and shall also be liable to fine. The illicit intercourse has the same meaning as in section 372, now it is 96. Now, see section 376, the punishment for rape. The offence of rape has been defined in section 375 and punishment has been provided in 376. This is very heinous crime, and we always see the reports from media that a child is raped or a woman is raped. It is very insulting, it is very cruel and heinous crime, particularly for Indian societies, where the women have always been respected and they have never been the subject of the pleasure or only the sex. But this crime of rape is the crime against the humanity. It is not the crime only against the woman, certainly it is a crime against the humanity, and therefore, this crime should be tackled or dealt with by the government with very strict and stringent manner. We have also seen the same approach of the Indian legislature and the Indian executive after Nirbhaya case in Delhi. The provisions in different laws which are in any way relate to this crime have been amended. See 76, where the punishment has been given for the offence or the crime of rape. Now, this 376 is substituted by section 64 of Bharatiya Nyaya Samhita 2023. Whoever, except in the cases provided for in subsection 2, commits rape shall be punished with rigorous imprisonment of either description for a term which shall not be less than 10 years, but which may extend to imprisonment for life and shall also be liable to fine. Subsection 2 provides for some cases under which whoever being a police officer commits rape within the limits of the police station to which such police officer is appointed, or in the premises of any station house, or on a woman in such police officer's custody, or in the custody of a police officer subordinate to such police officer, or being a police servant commits rape on a woman in such police servant's custody, or in the custody of a public servant subordinate to such public servant, or being a member of the armed forces deployed in an area by the central or a state government commits rape in such area, or being on the management or on the staff of a jail, remand home or other places of custody established by under any law for the time being in force, or of a women's or children's institution commits rape on any inmate of such jail, remand home, place or institution, or being on the management or on the staff of a hospital commits rape on a woman in that hospital, or being a relative, guardian or teacher of or a person in a position of trust or authority towards the woman commits rape on such woman, or commits rape during communal or sectarian violence, or commits rape on a woman knowing her to be pregnant, or commits rape on a woman incapable of giving consent, or being in a position of control or dominance over a woman commits rape on such woman, or knowing or commits rape on a woman suffering from mental illness or physical disability, or while committing rape causes grievous bodily harm or maims or disfigures or endangers the life of a woman, or commits rape repeatedly on the same woman shall be punished with rigorous imprisonment for a term which shall not be less than 10 years, but which may extend to imprisonment for life, which shall mean imprisonment for the remainder of that person's natural life and shall also be liable to fine. So, the offences which are provided under subsection 2 are considered to be more serious offences of rape. The situations which have been provided under subsection 2 of 76 are considered to be more serious situations or more serious act on the part of a person in such authorities, and therefore, you can see the enhanced punishment has been provided in these situations. In the further provisions in explanations, the armed forces hospital, police officer, women's children institutions are explained or defined. According to these definitions, armed forces means the naval, military and air forces and includes any member of armed forces constituted under any law for the time being in force, including the parliamentary forces and auxiliary forces that are under the control of the central government or the state government. Hospital means the precincts of the hospital and includes the precincts of any institution for the reception and treatment of persons during or of persons requiring medical attention or rehabilitation. Police officer shall have the same meaning as assigned to the expression police under the Police Act 1861. Women's children institution means an institution whether called an orphanage or a home or for neglected women or children or widows home or an institution called by any other name which is established and maintained for the reception and care of women or children. Now, see subsection 3, whoever commits rape on a woman under 16 years of age shall be punished with rigorous imprisonment for a term which shall not be less than 20 years, but which may extend to imprisonment for a life, which shall mean imprisonment for remainder of that person's natural life and shall also be liable to fine. So, if the rape is committed on a woman under the age of 16 years, then again the punishment has been enhanced. See section 376A, punishment for causing death or resulting in persistent vegetative state of victim. Now, it is substituted by section 66 of Bharatiya Nyaya Samhita 2023. Whoever commits an offence punishable under subsection 1 or subsection 2 of section 76 and in the course of such commission inflicts an injury which causes the death of the woman or causes the woman to be in a persistent vegetative state shall be punished with rigorous imprisonment for a term which shall not be less than 20 years, but which may extend to the imprisonment for life, which shall mean imprisonment for the remainder of that person's natural life or with death. The capital punishment has also been provided. See section 65 of Bharatiya Nyaya Samhita, punishment for rape in certain cases. Whoever commits rape on a woman under 16 years, which has been already covered by 76 clause 3, with rigorous imprisonment for a term which shall not be less than 20 years, the same punishment has been provided. And whoever commits rape on a woman under 12 years of age shall be punished with rigorous imprisonment for a term which shall not be less than 20 years. So, the two situations 16 years and 12 years are provided in section 65 of BNS. Then see section 376, sexual intercourse by a person in authority. Now, this is substituted by section 68 of Bharatiya Nyaya Samhita. Whoever being in a position of authority or in a fiduciary relationship or a public servant or superintendent or manager of a jail, remand house, other places of custody established by or under any law, or a women's children's institution, or on the management of a hospital or being on the staff of hospital, abuses such position or fiduciary relationship to induce or seduce any woman either in his custody or under his charge or present in the premises to have sexual intercourse with him, such sexual intercourse not amounting to the offence of rape shall be punished with rigorous imprisonment of either description for a term which shall not be less than 5 years, but which may extend to 10 years and shall also be liable to fine. Some shorter punishment has been given, because this offence does not amount to rape, but this has also been declared to be offence under the Bharatiya Nyaya Samhita and earlier in IPC. Section 376D of IPC talks about the gang rape, offence of gang rape. Now, it is section 70 of Bharatiya Nyaya Samhita 2023. The punishment for the gang rape is provided which would not be less than the imprisonment for a term which shall not be less than 20 years, minimum 20 years imprisonment, and it shall be punished with rigorous imprisonment for a term which shall not be less than 20 years. So, minimum punishment has been provided as 20 years and the maximum may be the life imprisonment, and the life imprisonment shall mean the same as it was the meaning of the life imprisonment for the enhanced punishment for the offence of rape. The offences under section 376D(a) and 376D(b) of IPC are now included within section 70 Bharatiya Nyaya Samhita. So, now 376D(a) in place of this, these offences have been considered within section 70. See 376E, punishment for the repeat offenders. Now, this 376E of IPC is substituted by section 71 of Bharatiya Nyaya Samhita 2023. Whoever has been previously convicted for an offence punishable under section 376, 376A, 376AB, 376D, 376DA, now it is 70 of Bharatiya Nyaya Samhita, or DB, again it is 70 of Bharatiya Nyaya Samhita, and is subsequently convicted of an offence punishable under any of the said sections. If the repeated offence is made by, so these repeated offenders are treated under 376E and now 71 of Bharatiya Nyaya Samhita, shall be punished with imprisonment for a term, imprisonment for life, which shall mean, so directly for repeated offenders the minimum punishment has been provided, the life imprisonment, and life imprisonment shall mean imprisonment for the remainder of the life, natural life of that person. Now, section 493 of IPC, which is substituted by section 80 of Bharatiya Nyaya Samhita 2023. Cohabitation caused by a man deceitfully inducing a belief of lawful marriage. Every man who by deceit causes any woman who is not lawfully married to him to believe that she is lawfully married to him and to cohabit or have sexual intercourse with him in that belief shall be punished with imprisonment of either description for a term which may extend to 10 years and shall also be liable to fine. So, for having the cohabitation or sexual intercourse in the deceit that that woman is married to that person, it is also punishable, and the punishment is maximum imprisonment for 10 years and fine. Section 496, now it is section 82 Bharatiya Nyaya Samhita. Marriage ceremony fraudulently gone through without lawful marriage. So, whoever dishonestly or with a fraudulent intention goes through the ceremony of being married, knowing that he is not thereby lawfully married, shall be punished with imprisonment of either description for a term which may extend to 7 years and shall also be liable to fine. Section 493 and section 496, these are two provisions of IPC, and now these are also included by Bharatiya Nyaya Samhita to prevent the woman from any deceit or from any such deceit on the part of a man or person who intentionally wants to cohabit or to have the sexual intercourse with that woman deceitfully. So, the deceitfully inducing the belief of unlawful marriage, and whoever dishonestly or with a fraudulent intention goes through the ceremony of being married. So, both the cases where there is the deceitful inducing a belief of lawful marriage and then cohabit, and if anybody without go through the marriage ceremony without lawful marriage, it is also punishable under the section 82 of Bharatiya Nyaya Samhita. Then section 498A, it is very crucial provision of IPC, and now this 498A is substituted by section 84 of Bharatiya Nyaya Samhita 2023. If there is any cruelty to woman by his husband or relative of husband, then it is punishable under section 498A, and this cruelty is punishable for the imprisonment for a term which may extend to 3 years and shall also be liable for fine. So, 3 years imprisonment and fine, it is the punishment under this section. Whoever being husband or the relative of the husband of a woman subjects such woman to cruelty shall be punished with imprisonment for a term which may extend to 3 years and shall also be liable to fine. We know that in India the instances of domestic violence are very common, and when with the same intent that the women may be protected from such acts of domestic violence, wherein the husband of the woman or the relatives of the husband of that woman always acts or do the cruel behavior with the woman, may be punished. The punishment is prescribed the maximum term of imprisonment for 3 years and fine. Cruelty has also been defined so that the provision not be misused. Any willful conduct which is of such a nature as is likely to drive the woman to commit suicide or to cause grave injury or danger to life, limb or health, whether mental or physical, of the woman. Harassment of the woman, where such harassment is with a view to coercing her or any person related to her to meet any unlawful demand for any property or valuable security, or is on account of failure by her or any person related to her to meet such demand. So, the meaning of cruelty is very broad in section 498A. Section 509 of IPC is also important provision, wherein the punishment has been provided for any words, gesture or act which is intended to insult the modesty of the woman. Any words spoken, any gestures made or any act done with the intention to insult the modesty of the woman is punishable under section 509, and this section 509 is now substituted by section 78 of Bharatiya Nyaya Samhita 2023. Under this section, any person who intends to insult the modesty of any woman, with that intention to insult the modesty of any woman, utters any words, makes any sound or gestures, or exhibits any objects intending that such word or sound shall be heard, or that such gestures or objects shall be seen by such woman, or intrudes upon the privacy of such woman, shall be punished with the simple imprisonment for a term which may extend to 3 years, and also with fine. Some new offences have been introduced by Bharatiya Nyaya Sanhita, which were not found in IPC. These are section 78 of Bharatiya Nyaya Sanhita and section 81 of Bharatiya Nyaya Sanhita. Section 78 talks about the sexual intercourse by employing deceitful means, and section 81 marrying again during the lifetime of husband or wife. So, if any person who marries during the lifetime of the wife, or any woman who marries during the lifetime of the husband, is also punishable under section 81, and sexual intercourse by any kind of deceitful means is punishable by section 78. The punishment has also been prescribed, shall be for section 78, when any sexual intercourse by employing deceitful means is made, then the person is punished with the imprisonment of either description for a term which may extend to 10 years, and shall also liable for fine. And for section 81, the punishment has been prescribed, the maximum punishment of 7 years shall be punished, either description for a term which may extend to 7 years, and also fine. So, these are the different provisions in IPC and Bharatiya Nyaya Sanhita, wherein the punishment has been provided, and such the IPC and now the Bharatiya Nyaya Sanhita protects the women from any kind of offences. Thank you very much.
I am A.K. Sharma and I teach sociology at IIT Kanpur. I am going to address the question, what is the relevance of statistics in sociology? In India, there is some confusion about role of statistics in sociology, and most of the students of sociology suffer from what I call phobia of statistics. But actually, if you look at history of sociology or the kind of work that are being done in sociology, which are published in prestigious academic journals, you find that there is a lot of use of statistical methods, and not simple methods, very advanced methods. All of you know, as students of sociology, you know that one of the founding fathers of sociology, Comte, or another founding father, Emile Durkheim, they said that sociology is one subject which differs from other subjects in the questions that they try to answer, but they use the same method, the method of science. And that in sociology, those who believe in this kind of approach, they are called positivists. Emile Durkheim called them positivists. They believe that social issues must be studied by using observations, experiments, and other modes of collection of data. Now, statistics can help sociologists in 3 ways. Because if sociology is about social facts or patterns, not individuals, patterns of thinking, patterns of feeling, patterns of acting, behaving, and they can be measured, they can be quantified, and that explanation of one social fact can be given only in terms of other facts. We need statistics, because statistics can measure these facts, statistics can describe these facts. So, one branch of statistics, we can call it descriptive statistics, can help us in summarizing data, in measuring facts, like you are all familiar with simple statistical things like mean, mode, median, or methods of dispersion, standard deviation, range, variance. These are descriptive measures. They can also be used to measure skewness or symmetry or asymmetry in the data. Other types of statistical methods, which are called inferential statistics, are used to test hypotheses. We know that any science, including sociology, if we follow that positivistic tradition, is about testing hypotheses using scientific methods. And for testing hypotheses, like for comparative purposes, comparing means of two samples or comparing variances of two samples or comparing correlation coefficients or regression coefficients, we need inferential statistics. And if you are familiar with some of them, t-test, z-test, chi-square test, f-test, these are the tests which come under inferential statistics. We use statistics for drawing inferences about two or more samples. And thirdly, statistics can also be used for posing new questions. I remember that a few months ago, I read an article in Population and Development Review in which the authors Cole and Gramajo, they tried to explain homicide rates and variations in homicide rates across countries in the entire world. And they found, based on statistical analysis, logistic regression and all, they found that one factor which explains variations in homicide rates in the world is female education, not culture, not governance so much, not even male education, but female education. Now, if facts are showing this, so you have a new sociological question: why is it that rise in female education leads to higher homicide rates? And Cole and Gramajo then gave certain hypotheses. You may not agree with those hypotheses. You may conduct this study on your own or test these hypotheses given by Cole and Gramajo using statistical methods. But the point I am making, that in addition to describing data, drawing inferences, statistical methods can also be used for raising new questions in sociology. And of course, you are all familiar that whenever the issue of prediction comes, predicting population of India, predicting urbanization, predicting per capita income of India 20 years from now, 50 years from now, there also statistical methods are of great help. And finally, statistical methods have been used in monitoring and evaluation of development policies run by various governments and NGOs. Thank you very much.